We'll go ahead and get started. So today's workshop, so I'm Allison Gutu. I am a supervising attorney and pro bono coordinator at Advocates for Children, and I work with my colleague, Michael Athy, who's here as well.
Hello, everyone.
And so we both work on the Charter Schools Initiative. So that's what we'll be talking about today. As a roadmap for today's training, we will do an overview. We will speak about promotion policy and academic supports in charter schools, special education in charter schools, discipline policies in charter schools, and remote learning, of course. I do want to note that most policies apply during the rest of the time pre-COVID still apply during remote learning, and we will get into that later specifically, but everything we're speaking about should apply during remote learning. Next slide. So this is a bit of trivia for you. Our question is, what percentage, oh, there we go. What percentage of New York City public school students attend charter schools? Do we have votes for 5%, 8%, 10%, 13%, 15%? Okay, so we will share the results. We have, we're sharing the results. So we have most of you, similar numbers of you said 10% and 15%. So actually, the correct answer is D, is 13%. So according to the New York City Charter School Center, approximately 136,000 students attended charter schools in the last year. So that's an interesting bit of data for you. I think we have another poll as well. So we wanted to know, yes, are you a student, a parent, an educator, another type of professional? Great. So we have our results. We don't have any students, but we have 7 parents and 11 other professionals. Great to know. Thank you for sharing that with us. All right, and we also, I think, want to know, yes, exactly where you are. So Advocates for Children works within the 5 boroughs of the city, but we're happy to answer questions as best we can for anywhere that you are, or refer you to organizations that work in your area. I see we have a strong showing for the Bronx. All right. Great to know. All right, so we have a lot of Bronx. You win. Bronx is in the house.
Be excellent.
Great. Well, thanks for yeah. Manhattan it's far behind. It's the Bronx is a clear win. Okay, good to know. So we can go to our academics in charter schools. And on the next slide, speaking about promotion policy in charter schools. So each charter school sets its own promotion or academic policy. Make sure to ask for a written copy of this if your child is entering a charter school or transferring to a charter school. The policies may include minimum attendance requirements. It may include higher grades to pass a course. So for instance, in New York City, DOE schools or Department of Education schools, required passing grade is 65. In a charter school, they can require a different grade, like 70. There may be a greater reliance on a student's performance on standardized tests or predictive screeners. Many charter schools don't offer summer school to students either, so they can't make up a class they failed and may have to repeat the entire grade. So it's important to check the school's policies before enrolling. As a result of these policies, students in some charter schools repeat grades at very high rates. Some charter school networks even demote students if they think the student is not on track to pass state exams. So if you're working with a youth that has been demoted, especially in the middle of the year, that's very serious. Please contact us in that event. So I think we have some more trivia for you. Another poll. We want to know what's going on. So what percentage of New York City charter schools, of students in New York City charter schools are multilingual or English language learners? Getting some strong predictions here. Leaning towards the higher numbers. All right, and we have the results. Most of you said 20%, and the least number of you said 7%. So the fact is that it's actually 7%. So as of the 2020-2021 school year, there were about 7% of students that were English language learners in New York City charter schools, as opposed to in the district, it's about double. It's almost 14% in district schools. So just a bit of information for you. And in the admissions lotteries, only 81 charter schools gave a preference for multiple language learners and English language learners. So in terms of multiple language and English language learners in charters, charter schools must provide English language learning instruction to help students achieve the same educational goals as all students. The law also specifically requires charter schools to implement bilingual education or ENL, or English as a New Language programs, or some other research-based ENL program that's been approved by their charter authorizer. Unfortunately, sometimes these other programs aren't actually evidence-based and may amount to not much support at all. While charter schools have flexibility in how they set up ELL programs, this instruction must enable them to develop academically while achieving competence in English. Teachers must have certifications to teach bilingual or ENL classes. And unfortunately, we have seen where teachers don't have the required certifications, so that's something to watch out for. Next slide. So, language access rights. Parents have the right to get documents translated, including report cards, parent handbooks, and IEPs. Parents have the right to interpretation services at school meetings and IEP meetings. And New York City charter schools have access to an interpretation service and to the DOE's sign language interpretation service. So in terms of parents' rights to translation and interpretation, Title VI of the Civil Rights Act would apply to charter schools, requiring them to abide by anti-discrimination laws, which forbid discrimination based on national origin. schools must have, quote, appropriate and competent individuals provide translation and interpretation. They cannot rely on students, siblings, friends, or untrained school staff to translate and interpret for parents. Note that the Department of Education is responsible for translating special education related documents specifically. So that would be the IEP, any evaluations, and they're also responsible for having an interpreter at the IEP meeting. So we'll talk more about that later, but the DOE is entirely responsible for the special education process for children in charter schools. So we're going to move to talking about students with disabilities in charter schools. And we have, I believe, another piece of trivia for you, or a poll. So true or false, charter schools must provide the services on a student's IEP. And we have a lot of responses coming in. I see most people are leaning in one direction, but not everyone. And here are the results. Most of you said true, and that is correct. Charter schools are required to provide students with the services that are on their IEPs. If schools cannot provide the specific recommended program on the IEP, they must provide, quote, specially designed instruction for the student. And we'll talk more about what that means a little bit later. So students with disabilities in charter schools who need an individualized education program follow the same process as students in district schools. And that consists of referral, consent by the parent for evaluation, the development of the IEP, and placement or services. Referrals are made directly to the charter school or to the CSE where the charter school is located. And the CSE is the Committee on Special Education. That's a branch of the Department of Education. Like district schools or DOE schools, the charter school can make a referral for an evaluation to the CSE. When a referral is made, charter schools should provide the DOE with information about the pre-referral intervention services that they have provided to the student before the referral. The DOE requests this information to ensure that schools are providing supports to students and to better identify what the school has already tried. If the student is in grades kindergarten through 5th grade and is being referred due to a possible learning disability, a description of the methodology, the interventions, or the strategies that were used must be included in the request form. So to clarify, that's just to say that if a charter school is providing some services before they actually refer the student for evaluation and for potentially for an IEP being developed, they need to make that clear to the department. And that process, if they're providing some services already at the charter school without the student having an IEP, should not prevent the charter school from referring or parent from referring a student to the Department of Education for evaluation. Both of those things can happen at the same time if that is what the parent consents to. In the same way as district schools, since the special education process is basically identical to that in district schools, we won't focus on each step, but in the next few slides, I'll just highlight the key differences and things you'll want to be aware of when working with a student with an IEP in a charter school. So the evaluation. The DOE, again, is responsible for conducting evaluations for students in charter schools. However, charter schools may conduct their own evaluations, and in fact, a handful do. However, the DOE may look at that outside evaluation in order to determine whether the DOE needs to perform their own evaluations. The CSE has discretion to allow charter schools to complete their own evaluations. So IEPs and charter schools. The charter school must provide student-specific information to an IEP team at an IEP meeting. The charter school also must propose programs and services for the student and must have special and general education teachers at the meeting itself. General education teachers are actually only required where the IEP team is considering general education for the student. If that's not an option that's being considered, then it's just the special education teacher that's required. Related service providers can also attend the meeting. The DOE, again, is the entity that's totally responsible for the IEP. So the DOE holds the meeting. It might be held at the charter school. I mean, now these are being held, via teleconference, but normally it could either be held at the charter school or at the CSE. The charter school representative must be knowledgeable about the special education resources and programs that are available at the school. Other charter school reps may attend the IEP meeting, but they're not allowed to replace the student's teacher. So some charter networks have staff that they send to IEP meetings as opposed to teachers, but that should not happen. According to the IDEA, the federal law that is for students, protects students with disabilities, a teacher who is familiar with the student should attend their IEP meeting. This also means that the CSE should not have a special or general education teacher from the CSE simply stand in for the student's actual teacher during the IEP meeting. So we want to make sure that's clear because it does come up a lot. And if an IEP meeting does not have all of the required team members and the parent has not agreed to excuse a particular team member, then you'll want to discuss with the parent about requesting that the meeting be rescheduled so that all of the appropriate and mandated team members are at the table. So moving to, IEPs and charter schools, yes. So student needs drive the recommendations of the IEP team. It is not what might or might not be available at the charter school. And that comes up quite a bit. Keep in mind that the parent can always invite anyone with knowledge of the child to the IEP meeting. So that can be a friend, a family member, a neighbor, and an outside service provider. But it's important to watch out for in terms of what's driving the recommendations for the IEP. Because, for instance, the school or the IEP team shouldn't be saying, well, we don't have a 12 to 1-to-1 class, for instance, if that's what's being considered or recommended. So the student should not attend the charter school, but they're going to need to go to a district or DOE school. That should not happen. The charter school needs to figure out what unique set of services and supports the student needs. This could include having a paraprofessional on the IEP. It could include a behavior intervention plan, check-ins, breaks, counseling, SETS, which is special education teacher support services, some other feedback systems. So in other words, the IEP needs to be very developed, a really good and very individualized IEP. There are also specific innovative charter school programs that exist. These are completely outside of the department's special education continuum that's offered. So for example, in New York, we have the New York City Autism Charter School, which provides specific supports for students with autism, including a 1-to-1 student-teacher ratio in most circumstances, which is very different from what most DOE from the DOE special education continuum and from charter schools in general. Keep in mind that program recommendations do not need to look like the program recommendations at district schools. The IEP program must offer students a meaningful educational benefit, and that the city can be creative with that. The IEP team can be creative with that. New York City, there's a guide to special education and charter schools that states that any innovative special education programs and services must first be authorized by the state, the city, or by the school's authorizer. The DOE must evaluate students, determine eligibility for special education services, revise IEPs, and where appropriate, declassify students, meaning remove special education services, only if that's appropriate and only if an IEP meeting and an evaluation is performed first. Charter schools, for their part, must provide the program and services to the students directly or provide services through a contract agency or ask the DOE to provide services. While the charter school can and should attend the student's IEP meeting and provide information about the student's progress, like teacher reports and things like that, the DOE is the final entity responsible for creating the IEP. Charter schools can implement IEPs in one of the 3 ways listed here. There's no hierarchy, so it's not like a charter school has to try to provide the services first. They can just ask the DOE directly if that's going to be the best way for the services to be provided. A note on providing the program. Many charter schools have ICT classes. However, an ICT is integrated co-teaching classes, a kind of special education class with 1 general education teacher and 1 special education teacher. Not all ICT classes are true ICT classes with 1 special ed and 1 general ed teacher. Some charter schools have 2 general education teachers in what would be termed an ICT class. Charter schools do have certain exceptions from certifications, but a child with an IEP must receive the services in the same manner as DOE students do. So if the child is entitled to an ICT on their New York City IEP, they do need to have, they are required to have an ICT classroom with a certified special education teacher. So if that's not happening, you should advocate if that's what you, if you want to enforce the IEP, you should advocate for an ICT class that does have a certified special education teacher.
And just to reiterate what my colleague is saying, the IEP is individualized to the student. It's not individualized to the school. So the IEP follows the student wherever that student may go. So it's important at the IEP meeting that whatever program recommendations there are, they're not catered to what the school can provide. They're catered to what it is the student actually needs and is appropriate for the student.
Absolutely. So moving to promotion criteria in terms of students with disabilities in charter schools. Charter schools may use their own promotion criteria for students with IEPs, and they can also request modified promotion criteria on a student's IEP. In the case of this type of request, charter schools must provide the following at the IEP meeting. They need to provide the school's promotion policy, the proposed modifications to any promotion criteria, and the rationale for the modified promotion criteria request. In our next slide, we have the guide to special education procedures for students attending charter schools. If you have questions about the special education process in New York City charter schools, you can definitely refer to this guide, and that's available on the New York City Department of Education website. The guide also contains a helpful escalation path at the end to help resolve a lot of issues that we see arise within charter schools. So here we just want to pause and see if there are any questions from the Q&A that we want to answer. If they don't have, sorry, just looking at the Q&A. If they don't have a certified special education teacher, but it's getting it a disadvantage to the student. Yeah, I mean, it depends on the individual student, right? So if a student has an IEP with certain mandated services on it, it just means the student has a right to those services and that the school should be providing them. So if the school, for instance, provides provides the services in a way, if there's two general education teachers and they're really effective for your, the child's needs, and the program is working and the parent thinks that it's right and agrees with the program that or the way the services are being implemented, that's fine. I mean, there's no, it's up to what works and is what is appropriate for the student. Just to know that the student has a right to uh, a certified special education teacher in the classroom, if that is what the student needs. There's a question on, let me see if I can go back to understand what that one refers to. How long does a typical IEP last? So if it's an IEP meeting, it runs the gamut. It can be very short, or it can be, half an hour, 2 hours, depending on how much there is to discuss. In terms of an IEP, how long the services last, it's 1 year from the date of the IEP meeting. How soon, as far as age, can an IEP be developed? So an IEP can be developed from, I believe, from age 5. Prior to age 5, there is a process through the Committee on Preschool Education that develops, it's very similar to an IEP, but it just has a different name. So it's like an IE, it's an IFP. There's a different, just a slightly different name. There's a question, is there a percentage of students who need it that mandates a charter school to obtain a service or a provider they do not already have? For example, is there a certain number of students who need occupational therapy that would mandate the charter to get an OT provider if they do not have one? That's a good question. I wouldn't say that there's a percentage of students. The ways that the charter school can provide the services are through their own. They can hire an OT provider, for instance, or a service provider. They can ask the Department of Education to provide that service. They can provide, or the charter school, can contract with another agency to provide that service. So there doesn't have to be a minimum number. Again, if a student, the IEPs are individualized, right? So it's specific to the individual student. If the student needs that service, the charter school needs to figure out how to provide it, and they have a few ways that they can do so. There's a question on high functioning. Yeah, high functioning is not really a technical term. I think some people use that term to indicate, like for a student maybe who has who has intellectual disability or has autism, meaning that the student may have a serious disability, but is also able to perform very well adaptively. Is able to relate, to travel, to just take care of their sort of activities of daily life, or maybe it's very cognitively high functioning, has a very high IQ, or does very well cognitively or in school, even though they might have other sort of social or emotional limitations. So we have a few more questions left, but we want to make sure to also move on. So if they're not answered in the chat, then we will try to come back to them at the end, or we're next able to pause. Okay. All right. So in terms of Section 504 in charter schools receive federal funding and are required to follow Section 504 of the Rehabilitation Act. This means that charter schools cannot discriminate against students with disabilities and charter schools must provide reasonable accommodations to students. So Section 504 also applies to parents with disabilities. That's important to keep in mind in terms of a parent maybe who has a mobility issue or other disability in terms of bringing their child to school or interacting with the school. Students with disabilities under Section 504 are entitled to a FAPE or free appropriate public education, reasonable accommodations and services so that they can participate in and benefit from school programs to the same extent as children without disabilities, and suspension and expulsion protections for behavior that is related to the student's disability, which are covered under Section 504. In terms of requesting a 504 plan, charter schools should inform parents of students' right to 504 accommodations and to the right to request a 504 plan. Parents or any doctors that are completing a 504 plan request form should specify the types of accommodations that the student needs. These can be classroom accommodations, testing accommodations, it might be breaks during the day, physical modifications, anything that the student would need. Make sure to put it on the form so that the school is on notice and hopefully can approve and provide those accommodations. So we're going to move into discipline in charter schools, and I will turn that over to Afi.
Hello, everyone. So everyone can hear me? Well, I guess only Allison can answer that question.
I can hear you.
All right. So I'm going to jump into discipline in charter schools, which is a common theme and topic that we receive here at AFC. So feel free to hop in with any questions. So I'll start off with a little poll and see what everyone thinks. Hopefully this should be the easiest one so far because it's only true or false. So true or false, charter schools in New York City must follow the DOE's discipline code. All right. So we have a resounding no. 76% of you said no, and that is correct. So charter schools aren't required to follow local regulations or discipline policies, including the DOE's discipline code. And we'll get into how that can make things a little bit tricky for parents and students at charter schools. So how are they different? Well, charter schools can create their own discipline policies, but these policies must be consistent with the requirements of due process and with federal laws and regulations governing placement of students with disabilities. And I will get into a little later about what due process looks like and what that actually means. But the key takeaway here is, although they don't have to follow the DOE discipline policy, they do have to follow their own discipline policy. Okay, so what is a lawful suspension in a charter school? Most important first is any suspension must follow the school's discipline policy. I know it sounds like I'm repeating this, but we get several calls, we get several cases where we find out that the school suspended a student for an infraction where in their own discipline policy, it said that a student couldn't be suspended for that infraction. Or school's discipline policy says that they will provide notice to a parent within a certain amount of time, or they'll say they'll provide written notice, and you find out that they didn't actually follow that. Or it'll say that a neutral person will oversee a hearing for a suspension, and you find out that And actually, a witness was the one who oversaw the hearing. So they're not neutral at all. So the first step is, if you encounter this, be sure to look at the school's discipline policy. Second, charter schools are permitted to do in-school suspensions, and they are permitted to do out-of-school suspensions as well as expulsions. So what are some examples of illegal removals? Well, a suspension for an undefined period of time. So that could mean you get a suspension hearing. You get a letter from the school, says that this student has been suspended, and the suspension will last until we can conduct a hearing. That's a common one that we see. Well, that's illegal. You can't suspend a student for an undefined period of time. And this is another, I'll go back to the previous slide. This is another part where you have to look at the discipline policy, because sometimes they will outline that for this type of infraction, it's a 1-day suspension or it's a 2-day suspension. So if it falls under the 1-day suspension, but for some reason the student got 2 or 3 days, they're in violation of their own discipline policy. Next are automatic trigger suspensions. So automatic suspensions are ones that kick in if a student commits a certain offense without any additional due process protection. So kind of think of it like a 3 strikes rule. You did X, therefore you get suspended. Well, sorry, that's not how it works. No matter what the infraction is, the student is entitled to certain due process protections before they can be punished. Conditional returns after suspension. So for example, a student can only return to school if they perform X, Y, or Z. They can only return to school if they do X, Y, and Z. That's not permissible. And double jeopardy. So double jeopardy, there is prior misconduct, prior discipline, there's suspension or some sort of consequence. The student then can't be suspended for that same offense afterwards. And I'll note that this includes mediation. So parent and student, they can go to mediation, they can get a decision. And once that decision is finished, the school can't then later issue a penalty for that same issue. And during a suspension hearing, anecdotal evidence can be discussed, but there must be a new offense. A student can't be punished for something they did before. And that's what I mean by anecdotal evidence. A student was in a fight a year ago, they're in a fight today. So this fight here, we're going to determine innocence or guilt on this fight based off of the fact that the student had a prior fight before. Well, I've been throwing around the word due process, and what do I mean by due process? So first, notice. And this requirement comes from a Supreme Court case. It's called Goss. And in that case, the Supreme Court notes that parents have a right to notice of the charges and the basis of the accusation. So that could be oral notice, that could be written notice. And notice must be prior to the suspension unless the student is a continuing danger or an ongoing threat of disruption to the academic progress. And what we see is that most suspensions, almost all suspensions, do not involve a student that is a continuing danger or ongoing threat. So the notice should happen prior to the suspension. And if immediate removal is allowed, notice must be provided as soon as possible after the suspension begins. Now, federal due process allows for oral or written notice. However, there is a state commissioner's decision which notes that written notice is required, and oral notice cannot substitute for written notice. And this notice should be in the parent's native language and be received within 24 hours of the decision to suspend. And you should check your charter school's handbook to make sure within their discipline policy that it outlines these procedures for notice. And the next step of due process is the right to be heard. So students have the right to an explanation of the evidence and the ability to tell their side of the story before they're suspended, unless they fall into these very extreme categories of being a continued danger to people or property, or an ongoing threat of disruption to the academic process. Students cannot be forced to give a statement against their own interest. Furthermore, under the right to be heard, for longer term suspensions, so that's 11 days or more, the school must prove the charges at the hearing. So, although the Supreme Court case from which we get the right to be heard in charter schools for long-term suspensions, it doesn't particularly describe what due process looks like, but it does say schools must follow more formal due process procedures when looking to suspend a student. And this case also requires notice and the opportunity to be heard for all suspensions. And we know that, excuse me, we know that more formal procedures must include these elements. And a federal district court in New York has also held that students and parents have a right to review evidence prior to a disciplinary hearing in order to prepare an adequate defense to the charges against the students. So I guess what I'm trying to say is that parents have very formal due process rights when it comes to disciplinary hearings. It's not necessarily the principal calls you, says your student is suspended, and sends you a letter. More needs to be done. And since an expulsion is a permanent suspension, we believe that the more formal procedures required for suspensions of more than 10 days are required for expulsions too. Hearings must also be on the record, and this is so the parent can have an effective appeal. And on the record could mean recorded in a way where the whole hearing is captured. What this doesn't mean is that someone at the school took notes for the parent. No, because in order for have an effective appeal, you would need a word for word recording, and that probably won't be captured if someone is just taking some handwritten notes. Now, we'll know a difference between charter schools and district schools is, so state laws require these more formal procedures for suspensions of more than 5 days. There currently is not a consensus in New York State on whether the 10-day rule or the 5-day rule applies to charter schools. But at the very least, make sure that the school is following its own code of conduct in holding a hearing for any suspension of more than 10 days. So a parent seeking to appeal a charter school suspension or expulsion must follow the grievance procedures in the Charter School Act. And the grievance procedure states that an individual or group may file formal grievance against a charter school when alleging a violation of the act, the charter, or any provision of the law. So the first step for appeals goes to the Charter Schools Board of Trustees. Hopefully this would be listed in the charter schools handbook, who the Board of Trustees is, how to get in touch with them. Next, the next line of appeal would be the charter schools authorizer. And this too, hopefully, is in the charter schools handbook. And lastly, the Board of Regents. The Board of Regents is delegated to the Educational Commissioner its authority to investigate and respond to charter school grievances. So it's really the State Education Commission that handles that last line of appeal. One unfortunate thing when it comes to appeals of charter school suspensions is that there is no set timeline for an answer at any level of appeal in the grievance procedure. Now, students with disabilities are afforded additional due process rights. So as we mentioned earlier, state and federal special education laws applies to students who attend charter schools, including federal laws like the IDA and Section 504. Therefore, students get things other students with disabilities get when they are suspended. These protections apply to students with IEPs, 504 plans, and students where the school is deemed to know the student may have a disability because the parent requested evaluations, expressed concerns, or based on the student's long-standing behavior challenges. For students with IEPs, the CSE is responsible for conducting expedited evaluations, functional behavioral assessments, behavioral intervention plans, and holding an MDR meeting. And I'll get into a little bit more about MDRs in the next slide. But for students with 504 plans, the charter school must hold the MDR meeting. And as a reminder, suspended students have the right to expedited evaluations if their parent requests an initial evaluation over the course of a suspension, or if the school is deemed to know the student may have a disability. These evaluations must be completed within 15 days, and the IEP meeting should be held within 5 additional days. So I mentioned MDR in the previous slide. So what exactly is an MDR? So an MDR is a meeting that takes place at the CSC. If a student with a disability has been suspended for 11 or more days, you should contact the CSC right away. The MDR is a meeting to determine if the student's behavior was caused by the student's disability or a result of the school's failure to follow the student's IEP or BIP, which is the Behavioral Intervention Plan. Now, who attends this MDR? The parent, the student, if it's appropriate, an interpreter, if needed, anyone with knowledge or expertise about the child. So this could be agency staff, service providers, therapists, and know that they can always participate by phone. So if there's someone that you want to be at the MDR meeting, but they can't attend in person, they can always participate by phone. Also, relevant school staff should be present. So someone who knows the student and can interpret information about their behavior. This should be usually a school psychologist or social worker. Yes, manifestation determination review, that is correct. Someone in the chat box asked what MDR stood for. So you have this MDR meeting and the CSC has to make a determination as to whether or not the behavior is a manifestation of the student's disability or not. If the behavior is a manifestation of the student's disability, the student cannot be suspended. They must return to their regular charter school placement. If the behavior is not a manifestation, then the student can be suspended like other students. If during the MDR, the CSC finds deficiencies in the student's IEP, placement, or their implementation of the IEP, even if they do not find that the conduct is a manifestation, they must take immediate steps to remedy those deficiencies. The CSC must do an FBA and if needed, a BIP. And if the student already has a BIP, they must review it to ensure it's still appropriate. Students in charter schools whose suspensions are upheld at the MDR don't get suspension plans like students in New York City District Public Schools. Under the IDA, they are entitled to services so they may continue to participate in the general education curriculum, although in another setting, and make progress toward meeting their IEP goals. School personnel, in consultation with at least one of the student's teachers, must meet and determine the extent to which services are needed to provide the student with a favor. This CSC will then determine what the services are in the interim alternative education setting where services will be provided. These services may not be the same as the services on the student's IEP. If the parent disagrees with the MDR decision, they can file an impartial hearing to appeal the decision. This hearing must be done on an expedited basis and scheduled within 15 days. If you are considering requesting a hearing for a student, please let AFC know. So I think that's a good time for us to stop and see if there are any questions on discipline within charter schools. So who can a parent appeal to if it seems, so one of the questions is who can a parent, okay, well, that was just answered by Allison. All righty. Is the CSC responsible for doing the FBA and the BIP or the school? The CSC is ultimately responsible for conducting the FBA and the BIP. Okay. All right. So I will move on now to remote learning in charter schools. So as my colleague Allison mentioned, pre-COVID, post-COVID, there wasn't all of a sudden new laws that were created to govern how charter schools should operate with students in their schools, especially with students with disabilities. So the charter school's obligations, especially when it comes to students with disabilities, they have not changed. I think there is a slight issue with the slide, but we'll work it out. We'll get through this together as a family. So IEP placement and special education services remain the same. This includes classroom placement, which could be ICT classroom, 12 one-to-one, 14 one-to-one, paraprofessionals. Classroom placement, whatever it says on the IEP remains in remote learning. School can't say, I know that your IEP says that the student needs a 12 one-to-one, but right now we're just going to put him or her in a classroom of 30 because it's easier or it's difficult to, it's been difficult to maneuver this. We all understand that there have been growing pains and it's difficult for schools, but their obligations to implement the IEP as written remain. This also includes related services. So counseling, speech and language therapy, occupational therapy, SETs, all these related services, if they remain on the IEP, then they should be implemented by the charter school during remote learning, as well as paraprofessional. Now, we understand that due to COVID, having a paraprofessional in the house is not going to happen, or it's very unlikely to happen, but they're able to have paraprofessionals work remotely with the students. Okay. So furthermore, when it comes to learning devices, charter school students are eligible for DOE iPads if the student has an IEP or if the student lives in shelter, foster care, or is doubled up. Parents can request a device if you just search on the DOE's website, remote learning devices. There is a portal there for parents to help request remote learning devices. If you're having issues with, if your child does not fall within the category of having an IEP or living in shelter, foster care, or doubled up, please reach out to AFC and we can help navigate getting you and your student the devices that they need. As well, the same discipline rules apply while remote. So look at the handbook, look at the policy, make sure that whatever discipline, whatever is happening with your child, with your student, one, falls within whatever is in the discipline policy, and two, falls within those requirements of notice and opportunity to be heard. We really hope that students aren't getting suspended for more than 10 days during remote learning. Crazier things have happened, but we really hope that during this period, this hasn't been as much of an issue. But if you see those issues persisting, also please reach out to us. So we'll end with a few takeaways. First, charter schools cannot refuse to educate multilingual learners or English language learners or students with disabilities. It's important if you live in a community where you know there's a lot of multilanguage learners or you know there's a lot of English as second language learners, but the charter school in the neighborhood doesn't seem to reflect that. That is an issue that I think we at AOC will want to be made aware of. Charter schools should offer specially designed instruction to students with IEPs who need unique supports and services. Charter schools also must implement the IEP of the student as written on the IEP. And charter schools should not change a student's IEP, or the CSC should not change a student's IEP to match what the charter school has unless the CSC believes that this is what is most appropriate for the student, what is best for the student. Students suspended from charter schools get due process and alternative instruction. And students with IEPs must get MDRs when suspended, especially when it comes to suspensions of 11 days or more. And I will note that on the MDR piece, it doesn't have to be a suspension, one suspension that was 10 days, 11 days or more. It can be cumulative. So if you had 1 3-day suspension here, 2-day suspension here, and then at some point those suspensions add up to over 10 suspensions, an MDR should be conducted by the CSC. And IEP services remain during remote learning. So a school can't tell you that the law has changed when it comes to IEP mandated services just because we're doing remote learning at the time.